NBC's journey began in the early 1980s under the Alexander Forbes banner, under the inspirational guidance and vision of our founder, Max Maisela, who dared to ask a simple question no one ever thought to ask. Why employees should not have a say in the design and management of their retirement funds. The right way, the fair way, the negotiated way, to ensure that all employees get the benefits to safeguard their dependents' financial well-being and to provide financial security for their own retirement. The concept of negotiated retirement funds with member representation on the Board of Trustees became the industry norm, and today it is law. In 1998, Max Maisela's dream became a reality, and after a management buyout, NBC Holdings Proprietary Limited was established, the first completely independent, black-owned and managed financial service company in South Africa. NBC has during the past 2 decades been part of an illustrious list of top-performing companies and received over 50 unsolicited local and international awards and accolades for innovative products and outstanding service delivery. NBC has an impressive list of clients, from government institutions within the SADC region, parastatals to blue-chip companies. NBC is committed to transparency and regularly facilitates educational workshops and communication sessions to keep our clients and the members of funds informed about benefits, investments, and all legal amendments pertaining to retirement funds. In the past decade, NBC has expanded into other African countries such as Namibia, Lesotho, Swaziland, Mozambique, and Ghana, where NBC works together with locally based partners to provide innovative financial products and solutions designed to meet the distinctive needs of people within that country. NBC has evolved and organically grown through self-funding into a multi-dimensional, highly successful and innovative company built on solid foundations and geared for healthy growth within South Africa and beyond.
Good morning, everyone. Thank you so much for joining us today. My name is Nicole Makoloko, and I will be your host for today's events. So today we're going to be going through some very interesting legal industry updates and some quite controversial topics as well. So hopefully everyone who's attending today will be very informed and will be kept up to date with what's happening. So just before I introduce our first speaker, I just want you to note that this webinar is CPD accredited. However, the certificate will only be issued after the live event, and you will have to download it immediately after the live event. The certificates will no longer be available after the event has streamed. And if you're watching this on recording, then as well, no certificates issued. So without further ado, let me introduce our first speaker. He is Mr. Liep van Zyl, who is the Head of Group and Legal at NBC.
There we go. There I can see my face. Good morning, everybody. I wish I had a beautiful smile as Nicole. This is as good as here in our legal department at NBC. We always have to do a little lottery as to who gets the regulatory topic. I lost that lottery. I was tasked to speak to you about the regulatory roundup. Now, it's typically a bit more boring than some of the case law topics, but equally as important because it tells you about the regulatory direction that our industry is taking. I just want to encourage you before I start that you please participate by means of typing your questions. I think you will find today that our presentations are a little bit shorter in an effort to try to create more time for questions and answers at the end. So please feel free to post your questions via the chat box. We will monitor them, list them, and then we'll address them at the end of the session in terms of whatever time is then left with our provider. With that being said, my regulatory roundup today will deal with seven topics. I will speak to each of these topics in a very cursory manner, and the objective of speaking to it in that fashion is that we want to inform you about the existence of these regulatory changes, and then to encourage you to take these topics to your next Board of Trustee meetings and or meetings with members when you are a member representative in your fund, so that your fund is best equipped to deal with these changes. The first one, so I'm going to give you a quick update on the two-pot system. Secondly, I'm going to talk to you about 5 taxation changes after the February 2022 budget speech. Then in the third place, I'm going to speak to the discussion paper on governance of umbrella funds that was issued by the FSCA in December last year. I'm going to speak to you about the FSCA regulatory strategy for the next 3 years. I'm going to talk to you about the amended foreign exposure for retirement funds after the February budget speech. In the sixth place, I'm going to talk to you about the FSCA strategy for transformation. And then lastly, I'll speak about a paper that was issued on the economies of scale in retirement funds, just briefly. Now, the first one is the update on the two-pot system. Now, just for those of you who may have forgotten, this has been motivated actually by the COVID pandemic. We saw that international jurisdictions were able to give quite handsome relief to pension fund members in international countries to help them cope with their cash challenges due to the COVID challenge. And South Africa at the time were also looking at a few ways of providing relief to its financially distressed pension fund members. We have up to date not been able to put something in place for them. And then during the course of last year, it actually started in the medium-term budget speech of 2020. We saw a discussion paper on a two-pot system that will broadly involve the following. Members will, from the implementation date, at this stage, it's still 1 March 2023, but at the end of my topic, I will tell you why I'm concerned about 1 March 2023 as an effective date. But from that date, members will be allowed to dip into 1/3 of their retirement savings on an ongoing basis, maybe 2 times a year. They will carry the cost for that. And then the price that members pay for that privilege is that 2/3 of their retirement savings will have to be preserved until the date of their retirement. So where members in today's regime can apply for their full withdrawal benefits when they leave employment, if the system is implemented, they'll only ever be able to access 1/3, and 2/3 will be subject to mandatory preservation until retirement. The good news is that our actuaries are telling us that this will bring about a very positive change in terms of preservation and the financial situation of members by the time they retire. Our actuaries tell us that members will be better off. The problem with the implementation of the two-pot system currently revolves around the practical implication thereof. There is no certainty, no policy certainty as to how the taxation of that one-pot withdrawals will work. There are also a few other legalities and complexities in terms of Section 37D deductions and then paid-up members and things like that that have not been resolved. So where are we in terms of implementing the system? The next step that needs to happen is that National Treasury has to publish the proposed legislation. Now, normally we receive the proposed amendments to the Income Tax Act around about June, July every year. So it's around the corner. Time will tell whether it will actually be in the amendments that are published to industry around about mid-year. And you remember that I told you that I have reservations about the about the implementation date being punted as 1 March 2023. I think there's no doubt from anybody in our industry that these changes will be cumbersome, they will be complex, and it will require significant changes to our administration systems. Now, when the proposed income tax amendment bill is published, there's usually space for comments there too, where industry gets an opportunity to state whether they believe that it can work practically. And therefore, there's very little time left before 1 March 2023 to implement whatever changes may be required. So that is just, in my personal opinion, I think it's going to be very, very difficult to implement the two-pot system by 1 March 2023. But time will tell. There's also a possibility that Treasury can issue amendments to the Income Tax Act that more or less retains the current taxation regime, which will lessen the amount of changes that we need to make to our systems. If that is the case, then I'll review my opinion. But at this stage, in terms of all the unanswered questions, I do not think that we will be ready to implement everything by 1 March next year. Just remember that part of that two-pot system proposal was also auto-enrollment. You will see when I speak to the governance document on umbrella funds, our government intends to deal with it. So that is also an open-ended possibility at this stage, and we'll have to wait and see until the legislation is issued for communication and comment. Then after the budget speech, there were 5 income tax changes for retirement fund members that I'm just going to speak about very briefly, because not all of them involve our day-to-day live members or members who are in active service. The first change is that members can now buy more than one type of annuity when they retire. Now, you remember previously we had SARS GN18 and GN18A that prohibited a member from buying more than one annuity when he retires. And the policy behind this was that SARS wanted to make it impossible for members to break down their retirement benefit into smaller investment amounts that could possibly fall below the de minimis of 167,000 Rand. That being said, SARS now and Treasury is giving acknowledgement to the fact that even though living annuities has had a very good run over the past decade or so, our simple reality is that retirees outlive their living annuities. They simply do not have enough money and capital to sustain them until, they die. The money runs out before they die. So there's an expressed need for retiring members to be able to put a portion of their retirement savings into a guaranteed annuity or a life annuity that gives lower income, but it's guaranteed until the date of death. So with the withdrawal of GN18 and GN18A, members are now able to purchase more than one annuity when they retire. Practically, therefore, a member can decide to put a portion of his retirement savings into a living annuity, which gives him higher monthly income, and a portion of it into a guaranteed annuity that gives lower monthly income, but is guaranteed until date of death. The only condition to this is that each of these individual annuities may not be less than 165,000 Rand, that being the de minimis under which threshold members can cash the entire benefit. Secondly, there's been a change with regards to transfers between retirement funds by members who are 55 years or older, specifically with regards to preservation funds. Now, you'll remember from 2020, it's been made possible for members who retire to put their money into a preservation fund for the first time, subject to certain conditions. They had to put their entire benefit into that preservation fund, and they wouldn't be allowed a once-off withdrawal. But these members were unjustifiably disadvantaged by the fact that they were not allowed to transfer between preservation funds if they are older than 55. That has now been rectified in the February 2022 budget, and they can now indeed transfer to another preservation fund tax-free. Or they could transfer previously, but they would have been taxed. That has been taken away. If they transfer to another preservation fund, that transfer will be tax-free. Unfortunately, it doesn't address the vested rights of members who are older than 55, who may be subject to a Section 197 transfer. Being transferred to another fund, they stand the risk of losing their vested rights, and we are awaiting developments in that regard, and we'll keep you updated. The third change was that self-insured risk benefits now also qualify for a tax deduction as a fringe benefit, similar to other deductions. So just to put it into practical terms, you will know that some large funds have opted to self-insure the risk benefits, the disability and death benefits, and even funeral benefits. But those deductions did not qualify as contributions and a tax deduction in terms of the Income Tax Act. That has now been fixed, and contributions to self-administration now also qualify for a deduction. The fourth change I don't want to say too much about, because it doesn't affect a great deal of our members. And those are members who stop to be South African tax residents. And I think for purposes of today, I should probably just make the following invitation. If you do have a member who's retiring, who's going to become a non-South African tax resident, please refer those queries to us directly. There will not be a lot of them, probably less than 1% of our membership, and it should be dealt with on an ad hoc basis. Then the fifth one also doesn't really affect live members who are still in service. It's also something that affects members that have retired. We call them annuitants. So these are now people who are in receipt of a monthly pension, either from the fund or from a annuity provider. There's been a tax change this year, and it basically only affects pensioners who have more than one source of income. So that would typically be a person with a rental property, or a person who's still healthy and got employed at a different employer and now is in receipt of a monthly salary plus his annuity income from his living annuity. So SARS have now fixed rates, higher withholding rates that annuity providers must comply with. And importantly, annuitants have the right to opt out. So if you do get a question from a previous colleague who has since retired, invested his or her money into a living annuity and got slapped with a massive tax liability this year, the best advice you can give them is to go to their annuity providers. It will be an insurance company or whoever, or an investment company, and they will be best suited to help these annuitants to structure their tax liability in the best possible manner. The third topic is a paper on the governance of umbrella funds that came out in December last year. And when you read this paper, you'll be left with an overwhelming sense that our regulator wants to end up with boards of funds that are entirely professional, who are, almost pension law specialists to govern these retirement funds. Now, there are some significant proposals in that paper. The first one that struck me is that there will no longer be a requirement that 50% of the board of trustees must be elected by the members. This should provide food for thought. Is this how far we have come? We know that retirement fund members in South Africa fought for the right to have representation on the board of trustees. Is that something that still needs to be accommodated in a commercial umbrella fund? Do you think it's important that members should still have the right to elect half of the board of trustees? Also, because the trustees that the FSCA are proposing to serve on these boards must be professionals, the FSCA intends to impose a limitation that they cannot serve on more than 3 boards in any given year, and that is to provide more opportunities for more trustees. These independent trustees may not be associated with any service provider in the industry. And then you remember when I spoke about the two-pot system and auto-enrollment, the FSCA is proposing almost like an auction system where umbrella funds are given an opportunity to bid for the right to be made the default auto-enrollment fund for members when that is legislated. The problem that I have, and I'll get back to this when I speak to the economies of scale paper, is that it's envisaged that these retirement funds and umbrella funds that will replace the standalone funds will be huge. So typically you will have a board of trustees that will be professional people, let's say they 12 in number. The 37C investigation is done at the participating employer's workplace. They make recommendations. It's physically impossible for those 12 trustees to be personally involved in these investigations. I envisage that there may be a tightly regulated system in terms of which they will purely rubber stamp whatever investigations have been revealed. Now that can work, and I think in 90% of the cases it does work. The problem is with legal liability. If something goes wrong in that decision, I think there's lack of accountability towards those management committees or representative committees at the participating employers, and we look forward to seeing some express legislative requirements in this regard. So you will see that comments were invited by 31 January. I can tell you that the industry has commented quite vigorously, and we were expecting to have seen a second draft by now, but that hasn't happened. When that does happen, we will notify you immediately. I don't want to say too much about the FSCA 3-year regulatory strategy. Safe to say that you must prepare yourselves for much more face-to-face engagement with the regulator at board level. We have seen a few letters to other pension funds in the industry where the FSCA has asked to join Board of Trustee meetings. And I think that fits in very nicely with this regulatory strategy that they have published. Importantly, and it links to the next topic, or the topic after the next one, they want to accelerate transformation of the South African financial industry and particularly the retirement fund industry. Then the foreign exposure limit increase in terms of Regulation 28 has been affected by many funds already. So previously, in terms of Regulation 28, a fund could not have offshore exposure of more than 35%, including 10% in Africa. That has now been amended. Boards can now have 45% foreign exposure. Africa is no longer mentioned separately, which means that investment in Africa is included in that 45% limit. I just saw an article in the papers this week where some of the investment managers are predicting an outflow of between 400 and 600 billion rands due to these increased offshore limit increases, but they're saying it's over a 5-year period. So don't expect any immediate and significant changes, but I do think it changes our landscape. Just keep in mind that while we're talking about Regulation 28, that there's also a version of amendments to Regulation 28 that is with Parliament currently for signature, and that deals with infrastructure development. And our plans are to have a detailed discussion only on those changes to Regulation 28 at our next seminar in August. The FSCA strategy for transformation, I respectfully also don't want to say too much about it because it's just a discussion paper, and it's a policy paper, which makes it difficult to make any concrete comments to. It's just that some of these objectives of the transformation by the FSCA respectfully contradicts, other policy decisions like moving into big umbrella funds. It is my personal opinion, not necessarily NBC's opinion. If we move all funds into big commercial umbrella funds, we will see that a lot of the smaller FSPs that are actually transformed and deliver a significant contribution to the retirement fund landscape will battle to survive and will battle to continue to exist. And I will affirm that point when I speak about the economies of scale paper. So you will see it's a two-phase plan. Please read it in your own good time. I think the real kickoff will happen once we get the next draft of the COFI bill that has been published from time to time. We've been promised that we will see the act later this year, and that's all that we have to go on. If it comes out later this year, we'll be communicating with you extensively immediately. Then lastly, and I have overstayed my welcome a little bit, is the economies of scale in retirement funds. This was a very interesting paper, and it's available on the FSCA website. And it deals with two periods that the actuaries commissioned by the FSCA took under investigation. The first study covered 1996 to 2006, and then the latest one that was published was up to 2018. And the authors of that report then highlighted certain pertinent changes that occurred between those two periods. Now, the findings of the report show that there's been a decrease in the number of funds. Now, that is fairly obvious. We've seen that a number of standalone funds have collapsed into umbrella funds, and it's not necessarily a bad thing. There's been an increase in the average fund size. That's also a logical conclusion to draw. But then, interestingly, there's been an increase in administration expenses as a percentage of the total assets over these two periods. Now, that seems out of sync with what the rest of the report says now. Now, I'm not an actuary, I'm not a evaluator. I can't go into the mathematical reasons for this, but it is a finding that could be worrying to the industry, that admin expenses as a percentage of the assets have increased over these two periods. And then lastly, the actuaries find that only once a fund reaches the size of 300,000 members do the administration costs come down per every member. Now, that is an interesting finding because it means that any fund that has less than 300,000 members is probably dealing with suboptimal administration costs as a percentage of assets. It also gives an indication as to how many funds will be required, umbrella funds, in the future, in line with the FSCA strategy to have only roughly 100 umbrella funds in total and no standalone funds. The problem with this is that it contradicts, the FSCA strategy regarding transformation. One of their objectives, if you read my slides, you will see, is that they want to improve the situation of small FSPs that are already transformed. I just think, and I may be wrong, unless we get very innovative and find very clever solutions, that smaller FSPs are going to find it very difficult to compete in an industry where the average fund size is 300,000 members. But that is something that NBC is working on continuously, so that we are geared for it strategically when it does happen. So, ladies and gentlemen, that is my presentation for today. Thank you for listening. Please post your questions in the comment section. If we have time at the end, we will address them comprehensively. Thank you.
Thank you so much, Lee. That was a very informative presentation. Up next, we have our divisional head for compliance, Esther Morishiki.
Trustee training. At NBC, we understand the importance of the role of the trustee. We aim to provide trustees of retirement funds and people employed in the retirement fund industry with an understanding of the responsibilities assigned to and expected of trustees. In addition, because of a rapidly changing environment, trustees are demanding more extensive and formal training to evidence their development. NBC Corporate Academy offer both a non-accredited course and courses that can be accredited by Mill Park Business School with the aim of acquiring an NQF5 qualification. For more information, please see our website www.nbc.co.za or contact us on info@nbc.co.za.
Good morning, everyone. Thanks for joining us today. We will be talking about the Draft Conduct Standard, where it relates to payment of pension fund contributions. And this is quite interesting topic because it's going to bring about changes as we look at changes that are brought about to Section 33 of the Pension Funds Act. All right, so the Financial Sector Conduct Authority, the FSCA, published the Draft Conduct Standard and issued a notice or communication for us to give out our comments on it, and it's currently sitting with Parliament, and this communication was sent to us in February of 2022, and once it's been published, we will have 6 months from the time that it's published to be compliant with the regulations or the conduct standard, so to speak. So the proposed changes that we see are, for instance, the minimum information to be furnished to a fund by an employer with regards to payment of contributions made by an employer in terms of Section 13A, and also notification and reporting obligations have been increased on the board of fund, principal officer, and any authorized persons. They would need to report, for instance, to the FSCA in case there are any contraventions or non-compliance issues in terms of Section 13A. And also we see some changes relating to the rate of interest payable on arrear contributions. And we're going to go into some detail looking at these changes and what they entail to the whole process that we currently undergo. So just to summarize the changes introduced by the Draft Conduct Standard, we said the employer establishing or participating in a fund, minimum information to be contained in a contribution statement, reporting and communication with members, interest on late payments, and outsourcing of the recovery of arrear contributions. And we're going to go into some detail to look at some of these changes. We're going to start with the employer establishing or participating in a fund and look at the changes that have been introduced by the FSCA. So in terms of that, a fund must notify every employer within 30 days of the commencement of an employer's participation in the fund, and annually thereafter, of the employer's duties, obligations, and liabilities under Section 13A of the Pension Funds Act. And this notification must be made in the format set out in the Draft Conduct Standard. I think it's Annexure A, which includes a request for the employer to provide the details of the persons at the employer who's responsible for the payment of contributions as required in terms of Section 13A(9) of the Pension Funds Act. Then if we look at the minimum information to be contained in a contribution statement, they have introduced quite a number of new information that needs to be included, and additional information is being proposed in respect of the initial contribution statement, such as where an employer has multiple pay points, the pay point which made the deduction, the contact person responsible at the employer or pay point dealing with inquiries relating to the contribution statements and payment of contributions, the identity of the person that is in Section 13A(8) of the Act must also be disclosed, and also member information relating to their ID number, employer PIN number, income tax number, contact number, email address, postal address, and residential address must be included in the contribution statement. The statement contribution or the contribution statement must contain all information as required in the initial contribution statement, as well as the membership number allocated to each member by the fund. It's also important to note that the members' contact details are required, as the board is expected to communicate personally with the member where there has been a non-compliance with the conduct standard. And this is quite an important change that has been brought about, because then once they introduce the requirement for all member contact details to be in this to be provided, then the board has access to each member whenever there's a non-compliance issue that is introduced. It will also assist in preventing unclaimed benefits occurring, because we see a lot of unclaimed benefits currently occurring in our systems. The next change that has been introduced is the reporting and communication with members requirement. So in terms of the reporting requirement, the administrator or responsible person who would have been appointed must, within 15 days after the minimum information was due, report to the principal officer or monitoring person regarding compliance with Section 13A. The report must include details on previously unresolved matters, and where the minimum information and actual contributions do not reconcile, unless the discrepancy is less than 2.5% of the total contributions, this must also be reported. Also, the principal officer, once the administrator has reported this, has an obligation to report within 7 days from receiving the report from the administrator to the board and submit a written report to the board for every employer if there is a current or unresolved non-compliance issue. And in that report, that written report, they must include matters such as whether the previously reported issues regarding any discrepancies that are over 2.5%, as I've mentioned before. The reporting to the board must take place within 7 days after the date on which the contribution statement was due, and no longer than 15 days. And then the board must communicate to the members within 30 days, or the affected members specifically, within 30 days of being informed of the affected members where there is non-compliance. If the affected members cannot be identified, then the board will need to report to the entire fund or the participating employers specifically for that fund. They need to communicate to those members. The board must report the non-compliance to the FSCA within 14 days of being informed of the non-compliance in the format that has been proposed in the draft conduct standard, and that is found in Annex B. And then if the non-compliance continues for 90 days, the board must then report this to the SAPS and use the format also that has been provided in the draft conduct standard. And also communicate with all affected members, as I said, in writing. And reporting non-compliance to the Attorney General and SARS is no longer a requirement. So that has now been repealed in terms of the draft conduct standard. The next requirement that has been introduced is the interest on late payments. For the purposes of Section 13A7 of the Act, a compound interest on late payments or unpaid amounts must be calculated from the first day of the month from due date until the date of receipt of the funds or of the funds by the fund. And it is prescribed to be prime rate +2, and it cannot exceed the principal debt due, inclusive of all the costs associated with the recovery of the unpaid amounts. And that is in terms of the Duplum rule, in Duplum rule. The next requirement that has been introduced is the outsourcing of the recovery of arrear contributions. So here they're trying to ensure that there is no conflict between the individual or the entity or law firm that it's outsourced to and the fund itself. They're trying to prevent that conflict to avoid inflated charges being charged on the fund itself. So that is quite an important requirement that has been introduced. So where a board outsources the recovery of arrear contributions to any attorney among others, the board must at least make sure or have regard to any actual potential conflict of interest that may exist in the selection and appointment of the collecting attorney. And also they need to ensure that the fees payable to the attorney for collection of arrear contributions are reasonable and commensurate to the service provided and do not impede the delivery of fair outcomes to the members of the fund. And also they need to enter into an agreement with the collecting attorney, which provides for a requirement that any amount recovered by the attorney in respect of the arrear contributions must be paid to the fund or the fund's bank account at least within 7 business days of receipt of such amounts. All right. And then we had a few industry comments that are of interest to us when the draft conduct standard was first issued. So principles of the conduct standard found support from the industry because in respect of the requirements for the employer to provide certain member details, as I've mentioned before, having those details made available now reduces the occurrence of unclaimed benefits and also promotes transparency. It makes it easy for the boards to communicate directly with the members, which has become an issue historically in the past because some member information was not always on file and hence we were not able to communicate with the members directly. Also, there were concerns on the difficulty of reporting cases to the SAPS. And then the FSCA indicated that they are liaising with the SAPS to make this process much easier and to ensure that there is a process in place that is understandable both from the SAPS side and from the funds perspectives that allows for deadlines to be met in terms of such reporting processes. And also there were concerns that were raised with regard to unwillingness of some employers to provide personal contact details of their employees. And the FSCA has said that they would like to introduce or impose penalties on such employers in future to force or implement that requirement of providing the contact details. And then the FSCA also indicated that the willingness to extend the period should it become a widespread problem for the industry. So obviously, once it's been implemented, they will also look at how it's working and then provide communication in terms of any changes that might need to be implemented in the future. That was it from my side. Thank you so much. I'll take it back to Nicole for the next presentation.
Thank you so much, Esther. That was an amazing presentation. Up next, we have our next speaker, Lerato Masemola, Divisional Head and Senior Legal Advisor.
Good morning, everyone. Thanks, Nicole, for that lovely introduction. Today, I'll be presenting on a very interesting case. There are a few lessons that we can learn from this case. I know Mr. Van Zyl loves this case. So I'm going to start briefly by taking you through the facts of the case. I'm also going to take you through the adjudicator's decision, the Office of the Pension Fund Adjudicator. I'm also going to take you through the High Court decision, the Supreme Court of Appeal decision, as well as the Constitutional Court decision. So the case that I'm referring to is the Municipal Employees Pension Fund and another versus Dineo Inocentia Mokgwanetsi and another. So briefly, the facts of the case are as follows. So Ms. Dineo Inocentia Mokgwanetsi was employed as a chief audit executive for a 5-year fixed period contract. Upon commencement of her employment in February 2012, she completed an application form for her membership of the fund, which is Municipal Employee Pension Fund. She was not, so when when she entered into the contract, basically when she applied for membership, at the time that she applied for membership, she was not informed that in terms of the rule of that fund, of this fund, only municipal employees employed in terms of a permanent contract could become members of the fund. Both Mrs. Mokgwanetsi and the employer contribution was deducted from her remuneration monthly and paid to the fund. So in November 2014, Ms. Mokgwanetsi discovered that the fund's rules did not allow for fixed-term contract employees to be members. So upon discovering the mistake, she asked for a refund of all her contribution, which was approximately 850,000 Rand with interest. So what she was basically asking for was asking for her portion of her contribution, as well as the employer's contribution, because according to her, she shouldn't have been allowed to be a member of the fund in the first place. So when she learned that she would not be refunded all her contribution, she lodged a complaint with the pension fund adjudicator and asked that the fund be ordered to refund all her contribution made to the fund, including interest. So this is both her contribution as well as the employer's contribution. So let's see what the the Office of the Pension Fund Adjudicator had to say. So subsequent to her referring the matter to the Office of the Pension Fund Adjudicator, in November 2017, the adjudicator determined that Ms. Mokgwanetsi had not satisfied the criteria for membership of the fund and so had not become a member and therefore was not bound by the rules of the fund. So just going back to what I had mentioned earlier, that only permanent employees can become members of this specific fund. So what the adjudicator basically said is that she should not have been allowed to become a member, as she did not satisfy a definition of a member in terms of the rules of the fund. The adjudicator then ordered the fund to refund all her contribution. So all her contribution referring to the contribution that she made, including those deemed to have been employer contribution, less the amount of whatever she had already been paid. So the determination was filed with the High Court in terms of Section 30M of the Pension Funds Act 1956, which had the effect that the determination was deemed a civil judgment of the High Court. So following this decision, obviously the fund was not happy with the determination by the Office of the Pension Fund Adjudicator. The fund then challenged that determination with the High Court, basically raising the issue of PAJA and in terms of Section 30P of the Act. So we're going to look at what the High Court's decision was. So the High Court has the same sentiment basically as the Pension Fund Adjudicator, in that according to their view, the Ms. Mokgwanetsi had not become a member of the fund simply because she did not satisfy eligibility requirements in terms of the rules of the fund. So the fund, so they were ordered to appeal. Sorry, they were. So the fund was instructed to refund all her contribution, which is her contribution, including the employer's contribution. So the fund was not happy with the decision by the High Court. The matter was then referred to the Supreme Court of Appeal. In its majority, the Supreme Court of Appeal upheld basically the adjudicated decision that all contribution had to be refunded to Ms. Mokgwanetsi. So basically the High Court and the Supreme Court of Appeal and the Office of the Pension Fund Adjudicator shared the same sentiment that Ms. Mokgwanetsi should not have been a member of the fund in the first place, as she did not certify the rules of the fund. So following those three decisions, the Supreme Court of Appeal based their judgment on unjustifiable enrichment because Ms. Mokgwanetsi's membership was based on a votable contract. So this basically meant that because Ms. Mokgwanetsi did not satisfy the eligibility requirements of a member, this contract that they entered into was basically void. So Ms. Mokgwanetsi then needed to be placed in the same position that she would have been had this error not occurred. So that means, placing her in the same position that she would have been meant basically paying all the contribution, not just her contribution, but also including the employer's contribution. So following those three judgments, the matter was then referred to the Constitutional Court on appeal. So in the Constitutional Court, on an unanimous decision, the Constitutional Code found that in terms of the rule of the fund, only employees employed on a permanent basis were eligible for membership. Ms. Mokgwanetse had never become a member of the fund and therefore should have never been admitted as a member, or in acceptance of her contribution had been ultra vires beyond its powers. The court found that Ms. Mokgwanetse was entitled to a refund of all her contribution by plus interest. So here we see that the Constitutional Court basically had the same argument as the previous three judgment, in that Ms. Mokgwanetse did not certify the eligibility requirements of a membership and therefore should not have been admitted as a member of the fund. So what can we learn from this very interesting case is that, number one, employers have to set out, pension funds and employers have to basically set out procedures to ensure that when employers bring on members to a fund, they are comfortable that those members meet the requirements of the fund. So there are a lot of risks associated with bringing on a member that will not certify membership in terms of the rules of the fund. And it's important that pension funds and employers are aware of the risk associated with that. Firstly, the judgment make it clear that a fund cannot rely on the ignorance of its third parties to justify keeping money it was never authorized by its rules to receive. Secondly, and most importantly, the judgment keeps the door of the Office of the Pension Fund Adjudicator open to those who have never been members or beneficiary of a retirement fund but have suffered prejudice as a result of its administration, investments, or interpretation or application of its rules. So it's also important to basically educate all staff, administrative staff, just to make them aware of the requirements of bringing on a member to the fund, and making them aware of who is eligible to basically be on the fund, to avoid the risk of the association of bringing a member that is not supposed to be on the fund. Thank you so much. That is it for my presentation. I hope it was clear, and thank you. Back to Nicole.
NBC Legal Services. The NBC Legal Department consists of qualified lawyers who handle generic and complex legal issues applicable to the retirement fund industry. In addition to our legal services, we offer free legal seminars as a tool to equip our trustees and employers with the appropriate technical knowledge through frequent seminars hosted across the country. For more information, please see our website www.nbc.co.za or contact us on info@nbc.co.za.
Thank you so much, Lorato. And now I'll be presenting another case study regarding the Municipal Employees Pension Fund and another against Mudal. So this member was employed by a district municipality, and in terms of his employment contract, he had actually belonged to the Municipal Employees Pension Fund. And then in May 2013, he was promoted to a new position. And therefore, he now ceased to be eligible to be a member of this specific fund in terms of its rules. So now, accordingly, he had accrued the right to be paid his benefit by the fund in terms of the registered rules. So those rules were binding on both the fund and the member in terms of Section 13 of the Pension Funds Act. So here's the issue. The rule stated early withdrawal of a member. So this is where they would be paid a benefit, an equal amount to 3 times the aggregate value of the contributions to the fund that had been paid to it by presumably or on behalf of the member. So what the board decided to do of the fund is they decided to ensure that the fund would have to remain financially sound in the long term. So they decided to amend this specific rule with effect from April 2013. So remember, the member left in May 2013. And so what they did is In April 2013, the rule changed to provide for the payment of a benefit in an amount equal to only 1.5 times the aggregate value of the members' accumulated contributions. So remember, before the rule had been 3 times the value, and now it had been reduced to 1.5 times. So the section that we need to be aware of here is not only this rule, but Section 12, subsection 1 of the Pension Funds Act, which makes it clear that an amendment would not be valid unless and until it had been approved and registered by the then registrar of the pension funds. This would have been the FSCA. So nonetheless, when calculating the amount of this specific member's benefit, the fund's administrator did not apply the formula in the then current registered rules. Instead, it calculated his benefit as if the proposed amendment to the rules had been approved and registered in terms of Section 12 of the Pension Funds Act. So just to summarize that quickly, what's happening here is a member is now entitled to the withdrawal of his benefit in terms of the rules that were currently registered at that point in time, which stated that he was supposed to get 3 times the value of his benefit at that stage. However, the trustees had made a decision, the board had made a decision to amend the rules in order to ensure that the financial stability of the fund is ensured in future, to reduce this amount. Instead of 3 times, it would be 1.5. The issue here is now the rule that they are proposing to be amended has not actually been registered at the date that this member specifically had left the fund. So this is what the court held in terms of the Supreme Court of Appeal. It held that the rules of a retirement fund may be amended to reduce the amounts of the benefits that have already accrued by the time that the amendment is approved and registered by the FSCA. So a unanimous decision was held by the SCA, and it stated that, firstly, Section 12 of the Pension Funds Act empowers the fund, subject to the approval of the registrar, or now the FSCA, to amend its rules and to determine the date on which the amendment becomes effective. Secondly, if by the amendment of its rules, the fund intends to interfere with the rights retrospectively, this intention must be given effect. And thirdly, as in this specific case, the fund had decided that the amendment would have been retrospective from the date of April 2013 in its application of the member's benefit had not been valid. So the fund's appeal was accordingly successful, and the member was ordered to pay costs. So let's just look at what Section 12, subsection 4 of the Pension Funds Act actually says. It says that a transaction effected in terms of this section shall not deprive any creditor or of a party thereto of any right or remedy which he had immediately prior to that date against any party to the transaction or against any member or shareholder or officer of such party. So what this section essentially means is, in terms of this case and the facts of this case, is that the member's exit date being before the actual rule, the amendment to the rule was registered, the formula should be applied that was pre the amendment of that rule. That is the formula that was meant to be applied in order to not deprive this member of any right due to him. However, what is happening in this case is the court is actually saying they agree with the fund that the rule amendment can actually apply retrospectively, regardless of the fact that this member had actually exited the fund before this rule had been proposed and registered. So what the board decided to do is, alongside the rule amendment, they applied this rule retrospectively and thus affecting this member. So what he thought would have been due to him, being 3 times the aggregate value of his benefit, has now been reduced, even though this rule was not actually in place at the time of his exit. So here's what the court was saying. So the fund attacked the decision that was previously held at the High Court on 2 grounds. Firstly, they attacked it on the basis that the decision held by the adjudicator's powers, the complaint fell outside the scope of the adjudicator's powers and therefore should be set aside because it did not comply with the definition of a complaint. And secondly, the fund stated that the adjudicator actually had made an error as a matter of law in finding that the amendment could not be applied to withdraw benefits which accrued before it came into effect on the 1st of April 2014. So the actual rule was registered and amended a year after this member had exited. However, as I said before, the board had decided to apply this rule retrospectively. And now the fund was looking to attack this matter on 2 points. The first being the adjudicator had no right to even deal with this complaint. And secondly, it was that the adjudicator had erred in a matter of law. So the court looked at the first issue, and it looked at Section 1 of the Act defines a complaint as one relating to the administration of the fund, the investment of its funds, or the interpretation and application of its rules. So thus the adjudicator is empowered to investigate and make a determination in respect of a complaint lodged by any aggrieved member. The court further held, the judge held that it is manifest that the adjudicator ruling that the member was entitled to pension benefits calculated in terms of the original rule was predicated on her finding that the amended rules could not be applied before they were approved and registered by the registrar at the time. And thus the complaint before the adjudicator fell related to the interpretation of the application of the rules, and the court held that this fell within the scope of her powers vested in her as the pension fund's adjudicator. So the first issue, the court felt that this falls within the realm of the adjudicator's powers, and thus that was set aside. However, the big issue here is the second issue that the fund held. The fund presented that, remember the fund is saying that this rule amendment should actually be applied retrospectively and thus affecting this member, even though they had at the time exited the fund when the current rule at that point had allowed for him to actually receive a benefit of 3 times the value and not just 1.5 times the value as per the proposed rule amendment. So the court held that this issue, thus, as I said, is relating to the retrospective, which is the application of the amendment of this rule. The amendment rule would then take effect from the date determined by the fund concerned. This is what the court held. And if the fund has not determined the date, the rule becomes effective on the date of that rule's registration. So now what the member's attorney then argued is that the amended rule was actually intended to operate retrospectively and to reduce the member's benefit with effect from the 1st of April 2013. So the fund's respondents then said they did not take issue with this, but what they argued is that because of the members' benefits had become due, they were in fact paid they should have been paid before the rule was registered. An amended rule cannot apply to his specific withdrawal benefits. And he was accordingly entitled to be paid in accordance with the rules which were in existence on October 2013. So remember that this rule became registered only in April 2014, whilst this member had exited in 2013. So what the members' attorneys were arguing here was that this rule had not yet actually been applied or should have applied to this member. And what should have happened is that he should have been paid his benefit in terms of the rules that were in place at that point in time. So what the court held then is the judge said that the plain and the ambiguous language of the amended rule simply does not brook this contended construction. And the amended rule explicitly states that it operates retrospectively and thus reduces the pension benefits due to the members with effect from April 2013. So he said that, in my view, there can hardly be a clearer indication of an intention to interfere with the existing rights with effect from that date. And he further stated that he concludes that the amendment rule retrospectively applied to all pension withdrawal benefits which had accrued to the fund's members after April 2013. And he further just commented that it may be unfortunate for this specific member, but the amendment applies to his benefit as well. So now the issue with this is that if the judgment of the Supreme Court of Appeal is not overturned, the rights of the members and beneficiaries of retirement funds are subject to regulation and supervision in terms of the Pension Funds Act will become very uncertain, because now rules can be effected retrospectively. So now I'm also going to go into some comments that were written by Rosemary Hunter regarding this case. So this matter, the judgment was handed down on the 14th of April of this year, 2022 actually. And she wrote quite a harsh and long commentary that I'm just going to go over some of the points that she mentioned that I think might help assess what issues this ruling can make. So firstly, it is to note that the fund's appeal at the Supreme Court of Appeal was successful, and the member was then ordered to pay costs. So she states that she feels that the court started the analysis at the wrong point, and that is the intention of the fund when it adopted the rule amendment. What she says is that the court should have started with the analysis of what Section 12, subsection 4 of the Pension Fund Act allows and does not allow in regard to the effective date of a rule amendment. So what this subsection, remember, it stated that it simply says that the fund can determine the date from which an amendment will be effective. It does not explicitly state that the amendment may be made either retrospective, in effect that it is prospective in effect, but imposes new conditions in relation to events that occurred before the amendment was approved, or secondly, it doesn't explicitly state that the amendment may be retrospective in that it changes the rights and obligations of members and the fund from what they were before the amendment was approved, and thus can have an adverse impact on the rights accrued by members and beneficiaries in terms of the pre-amendment rules. So in these circumstances, the court was not actually entitled to assume, and this is in Rosemary Hunter's opinion, it wasn't entitled to assume that Section 12, subsection 4 was intended to authorize retrospective and even retroactive amendments. Instead, time-honored legal principles required it to find that the section does not permit any interference with the rights accrued in terms of the pre-existing laws or rules. And by doing the opposite of this, the Supreme Court implicitly actually endorsed past conduct by the fund, which was not authorized by the then registered rules of the fund, which was, as the court had stated, reminded us, therefore, is this creates an unlawful and invalid amendment. So what we're looking at now is just maybe the implications that Rosemary Hunter feels would be applicable in terms of this ruling and how it may affect the retirement fund industry. So now, if the judgment of the Supreme Court of Appeal is not actually appealed, like I said before, the rights of the members and the beneficiaries of retirement funds subject to the regulation and supervision in terms of the Pension Funds Act will become very much uncertain. And we're going to go through two examples. So the first one is, for an example, when we look at, let's say we're engaged in a financial planning situation. A fund member may take into account the fact that if she dies before her retirement, then in terms of the registered rules at the time of her retirement fund, the fund will pay a lump sum benefit equal to 3 times her pensionable remuneration, plus their accumulated retirement savings in that fund. That lump sum can then be shared amongst potentially her beneficiaries in proportions that the board of the fund considers fair and consistent with the social security purposes of the Section 37C of the Pension Funds Act. So now remember that this member, hypothetically speaking, is looking at what decisions to make in future regarding their financial planning. But now what this specific decision is doing is that it allows that a board of the fund would be entitled to procure an amendment to the rules with retrospective effect from the date before the member dies to reduce or even eliminate the amount of the lump sum benefit payable on their death. And even if by the time the rule amendment has been registered, the board still has allocated shares of the lump sum benefit to this beneficiaries, and the amount now that this member had considered before as whilst financially planning that would be available to beneficiaries has now been either reduced or eliminated, and this would affect the decisions that she could have made had the rules not been applied retrospectively in this manner. So thus, even in a financial planning situation, your future is uncertain because the board can make decisions that apply retrospectively to your actual benefit. Another example that we can look at is maybe where a member of a fund who has accrued a right to a benefit in terms of the rules of the fund when they were dismissed from employment, they might only claim the benefit several years later and may find that by an amendment made to the fund's rules, after the member was dismissed, the fund sought to delegate an unclaimed benefit fund its liability for the payment of the benefit. So now, if this member had not agreed that the first fund's liability for the payment of the benefit could be shifted to the unclaimed benefit fund, they can still claim their full benefit from the first fund. The answer for this should be yes. So now it is a principle of the common law of obligations that ordinarily a debtor, in this case, the first fund of this example, cannot delegate its liabilities to a creditor, being the member, or to a third party, the second fund, unless the creditor both consents to the delegation and specifically agrees that the third party, being the second fund, will be its debtor in place of the original one. Now, failing which, both the third party and the original debtor will be contractually the creditor. So just in conclusion to this, what Rosemary Hunter is calling for in terms of this decision is that perhaps an appeal needs to be made in this matter that goes straight to the Constitutional Court and really address the issue of the interpretation of Section 12, subsection 4 of the Pension Funds Act in a manner that will be consistent, as we mentioned before, Section 13.7a of the Pension Funds Act, which I have quoted here below, which states that, save to the extent permitted by the Act, the Income Tax Act, and the Maintenance Act, no benefit provided for in the rules of a registered fund, including any annuity purchased or to be purchased by the said fund from an insurer for a member, or rights to such benefit, or rights in respect of contributions made or on behalf of a member, shall, notwithstanding anything to the contrary contained in the rules of such a fund, be capable of being reduced, transferred, or otherwise ceded. So just to summarize that, Section 37A states that outside of the applicable legislation, a member's benefit cannot be reduced by fund rules, cannot be reduced, transferred, or ceded. And this also, in this, hopefully an appeal will come forth. She also suggests looking at Section 12.12 of the Interpretation Act, and as well as the Constitution, and in particular the supremacy of law enshrined in Section 1 of the Constitution. So that is all for today. Just to summarize that again, what this case looks at is where a member specifically exited a fund on a specific date, and what the Supreme Court of Appeal has stated is that a rule amendment basically reducing his withdrawal benefit retrospectively can be made by funds at this point in time which will now affect members in making their financial decisions. That is the summary of my presentation. Thank you so much for listening. And now we will hopefully have some time to actually go through some questions that one might have. I see there are several questions, and we're just going to take a moment just to get our panel back together on screen, and we'll be taking some questions. Hi, everyone. So our panel is back, and we're just going to be looking at some questions that we have received. We've got a bit of time, so I think we can begin. I'll pass it over to Lieb just to guide us through our questions.
So the first one is, I would like to find out about any legal limitations to changing the retirement age. Can we reduce the retirement age from 65 to 60? What is the process to be followed? What consultation should be done? This is a complex question, and there is no simple answer to it. And that is based on the fact that in South Africa there's an overlap between our labor law and our pension law. So issues about retirement age is something that typically sorts under labor law, but also pension law. I saw a write-up last week that a labor lawyer wrote about, but he wanted to increase the retirement age. And I was thinking of doing a legal update about that. But the general principle in pension law is that trustees of a pension fund do not get involved in the employer-employee relationship. In other words, retirement age typically sorts in terms of your conditions of employment. So that sorts directly under employment law. But then the rules of your fund will then speak to whatever your conditions of employment are. That being said, you do have a few rights that you can enforce. And those rights roughly are as follows. Number one, your pension fund membership is regarded as part of your remuneration. Boom. There's case law to that effect. It's indisputable. It's part of your remuneration. Secondly, Section 23 of the Constitution says that you have a right not to be subjected to unfair labor practices. Boom. That's a right that you can enforce. Thirdly, there's case law to the effect that your pension fund membership and your benefits that are part and parcel of your employment relationship and your remuneration package can constitute an unfair labor practice. Okay? Now, those of you schooled a bit more in labor law will know that you then distinguish in labor law between a dispute of right and a dispute of expectation. Now, a dispute of right you will typically enforce either in the CCMA or in the labor court, while your benefit expectations is something that you will tackle through collective bargaining there. So my best advice to conclude everything that I've said here is that you can negotiate with your employer about your retirement age. There's no doubt the law allows for it. The second question then is, how do you do it? My suggestion is, because it doesn't involve a right, but a benefit expectation, that you try to resolve that matter through collective bargaining. If you're a member of a union, engage your leaders and, follow whatever processes are in place to get that question properly placed on the table for discussion. But it is not a simple discussion, I must warn you. In South Africa, where we have a youth unemployment problem, you will probably find that employers are more likely to want to reduce the retirement age. In Europe, we're seeing the opposite. The retirement age is being increased because people stay healthier for longer. We spoke earlier in my presentation about the fact that people now outlive their pensions now. So the longer you are able to work, the longer time you have to accumulate savings, and the better your chances for providing for your retirement adequately. So it's not a simple discussion, But those are the avenues that I would have followed. I would have gone to my union and asked them to table it with my employer formally. But it is not something that the pension fund will be getting involved in. If the employer then communicates that the retirement age has been changed, the pension fund will have to engage whoever underwrites the risk benefits, because that will have implications to the risks of those underwriters. I hope that answered your question. Number 2, the de minimis value has been increased to 247,500. It looks like a remark, but I think it's got to do with the fact that I spoke about 165,000. Lerato, can you take this one for us, please?
Thank you, Mr. Fanzel. So thank you for that lovely question. So you are correct. It is actually 247,500 Rand. However, the 2/3 refers to the 165,000 Rand. So you are correct in your summary.
Yeah. So then, just to clarify, and it links into the fact that members can purchase more than one annuity, provided that not any one of them are below 165,000. Remember, that's the 2/3 value of 247,500. The minute that it goes below 165,000, you can cash it in, nay, and that is what SARS and Treasury do not want. Question 3. Could we have feedback on the member portal and administrator portal? Our staff cannot fully use the member portal and administrator portal, not updated at all. Would I be able to update it? Maybe put up question 4 too, please, Jackie. How far is the process of activating the member portal and administrator portal? I know compliance plugs into this. Esther, can you take this one for us?
Thank you so much, Liv. So with regard to that, there are certain indemnities or disclosures that you need to now sign in terms of the Protection of Personal Information Act. And until you sign such disclosures with your employer, unfortunately, we cannot give you access. So what I recommend is that you communicate with your payroll to make sure that these indemnities have been signed, or these disclosures have been made and you've signed to that effect. And then we, of course, will give you or grant you access to the portals that you're referring to. I don't know if there's anything that you'd like to add to that, Lee?
Yeah, so the best advice probably is you go to your payroll office, your HR representative, make sure that all the indemnities in terms of the POPIA Act have been signed. And then you can communicate to any one of the 4 of us if you are still experiencing problems, and we'll try to assist you so that you get that access. There's no logical reason why you should not have access. Jackie, I saw there are 2 new questions that came in. You can post them, please. Then question 5. This looks like yours, Lerato. The Mongakwetse judgment by the Constitutional Court raises a number of questions regarding null and void membership of retirement funds. Can you please elaborate? Yeah, I was thinking about the same thing, Lerato, before you respond. I was thinking of something that we unfortunately start seeing in the pension fund industry, and that is that people join employment of employers with fraudulent ID documents. They then become members of the fund unlawfully due to a misrepresentation, and then when that fraudulent misrepresentation comes out, either when the person dies or when he leaves and wants to be paid and cannot verify a bank account, it then becomes a legal dilemma. What are your thoughts on that, Lerato? And because we don't have a court judgment on this particular topic, I would just like us to circulate everybody's thoughts around this topic.
So, so basically, what they're saying is that in order for a contract to be valid, there has to be 2 parties, and there has to be legal obligation in terms of that contract. The reason why this specific contract was null and void is that Mr. Mokhanetsi was not eligible for membership in the first place. And it's on that basis that basically made that contract void and null and void, because she was not eligible for membership. She was not permitted to belong to the fund because she was a fixed term employee. And because of that, the contract in itself was void and null, and she needed to be placed in the same positions that she would have been had this error not occurred, which means, so placing that person in the same position that they would have been means paying all her contribution as if she was never admitted as a member in the first place. So that means when they say null and void, there was never a contract to begin with because she was not eligible for membership, and therefore the contract became null and void, and she should have been placed in the same position that she should have been had the error not occurred. That means paying all her contribution. I hope that answers the question.
I think you're right, Lerato, but there's a lot of interesting legal developments that are taking place as we speak. We know that the fourth industrial revolution talks about platform work, where, you know, it's not unlikely that the four of us sitting before you will not be formally employed by NBC in future, but we'll be sitting on some platform like an Uber driver. A pension fund will contact us with, you know, via an app and say, you know, I have this PFA complaint, can you please provide me with legal advice? That's the future. The problem is, what labor protection can we give platform workers? So there's significant litigation in the background by Uber and Bolt drivers to receive recognition in terms of the Labor Relations Act. Over and above that, I can tell you about two recent decisions in the Labour Court that let loose the cat amongst the pigeons. The one was a immigrant that worked for Discovery and then failed to renew his papers, so he was in the country unlawfully. And the second one was a sex worker who instituted proceedings against the brothel owner, in terms of which he claimed certain protections under the Labor Relations Act. And what the Labour Court said that is interesting for our discussion here today is that the fact that the contract of employment may be illegal does not automatically make the employment relationship illegal. I'm going to say it slowly again. The fact that the employment contract is illegal does not automatically make the employment relationship illegal too. So in other words, in those two cases, the court said that the illegal immigrant in the Discovery case does enjoy protection under the Labor Relations Act, and ruled similarly in the sex workers case. Said that even though a contract of employment to work as a sex worker is an illegal contract, that does not automatically make the employment relationship illegal too. Now let's apply this to our case study about a person joining employment with a fraudulent ID or a fraudulent passport. Now, if the Labour Court is right, then we have to accept that that person joining employment illegally does not automatically mean that his employment relationship is illegal too. Now that creates a bunch of legal questions that the Constitutional Court did not pronounce on. But I do think the main guiding principle that you eloquently stated, Lerato, was that you have to place the parties into the position they would have been in if this illegal action had not happened. So from the pension fund's perspective, we fully agree with the judgment in Mongakwetse. We should refund all the contributions, the employer's contributions plus that of the employer. Where it gets very complicated, and I'm not going to test you, Lerato, because I don't even have the answer for this. What if it's a death benefit, and the underwriter of that death benefit says, I'm not going to honor this GLA claim, because if I had known what the true identity of this member was, I would have viewed my risk differently. Would they be entitled to repudiate a GLA claim if a person dies after having used a fraudulent ID? I don't have the answer to that. I think the safest way would be for the underwriter to also return the premiums that had been received unjustifiably. But the family of the deceased person who committed this fraud is now in a significantly weaker position there, because the person who perpetrated the fraud did offer his services, went to work meticulously, diligently, and there's nothing to show for it. So I do think that it's something that we will find more clarity on as time goes on. And I hope that our discussion stimulated some thought around the topic for you. Jackie, I see there's a question 9 also. You can post it for us. Oh, you have posted it. So let's see the next question. The judgment about retrospective rule amendments contradicts everything we know about pension fund principles, and I tend to agree. Nicole, what are your thoughts?
I agree as well. I mean, that's the commentary that we're actually getting from Rosemary Hunter as well, is that things have been done in a particular manner, and we should be following previous principles that we have, our common law principles as well. And what this does is it undoes everything and just creates a bit of chaos for us now moving forward. So definitely that is the correct comment. It definitely ties in with what I think we all agree on in terms of that judgment.
Yeah. So related to that question, Nicole, in the last legal case covered, if the former members do not have the finance or the means to appeal the case, how would it then progress to the Constitutional Court?
You know, this one can be a bit tricky, but in instances where this kind of judgment will affect the industry as a whole, there can be a lot of key players who might want to be involved in actually assisting financially for this member, just in terms of how big this kind of change may be. So it could be going from, getting some form of legal aid assistance to maybe even approaching some of the big industry players, because this is quite problematic as well for, just industry players in terms of the pension funds, members, beneficiaries, etc. can also be assisting. There's even some NGOs that assist with doing this. Law firms also have an obligation to do pro bono work. So if they could find a law firm that was willing to act on behalf of this member pro bono, that would be something that can be looked at as well.
Yeah, quite interestingly, Nicole, in the Mogakwetse case that you discussed, Lerato, in the Constitutional Court, you can actually go and view the trial on YouTube.
Yes.
But Freedom Under Law appeared as a friend of the court, that we call in Latin amicus curiae. So what it said is, we are not a party to these proceedings, but we're an NGO. We call Freedom Under Law. We believe that there's a legal principle that needs to be addressed in public interest. And Advocate Sandile Kumalo actually appeared as a friend of the court in the Mogakwetse matter. So that's also a possibility. And I must say, after having read Rosemary Hunter's criticism, I got the sense that this is maybe a case that she may want to take on pro bono, but time will tell. Okay, the next one. Whose responsibility is it to communicate to employees when your pension fund hasn't increased? And how should this communication be made to the employees? Lerato, I'm catching you off guard. Is this something you want to tackle?
Whose responsibility is it to communicate to employees? So it's the fund's responsibility. But if the fund has appointed an administrator to perform those functions, I would assume that the administrator is responsible for communicating to the employees, and the employer as well has some sort of duty and responsibility as well, in addition to the administrator and the fund, to communicate certain things to the employer as well. So all parties need to communicate, but I think the ultimate responsibility lies with the fund and the administrator as well.
Yeah.
Communicate.
The buck stops with the trustees. You're right, Lerato. Section 7 of the Pension Funds Act, 7D, capital D, says that the trustees must communicate adequate information to their members to allow them to make informed decisions. That's a statutory duty. With regards to the method of communication, there's no hard and fast rule. We live in the 22nd century. You can use WhatsApp, you can use a website, you can use all forms of modern communication, provided that you comply with the test, that it's adequate information to enable the members to make an informed decision. Which links into the previous question that we had about the member and administrator portal there. So those could typically also be used to communicate stuff like this. And I think our biggest challenge in the pension industry is to communicate these things in understandable language I think we're all guilty of that. We use language that are above our members' pay grade, and then it's not effective communication. Around the two-pot system, what are the tax implications around it, and how will the service providers handle the admin? Will they outsource admin, or will they handle it in-house? Yeah. So that is one of the outstanding issues from my presentation that has not been answered yet. At this stage, the balance of probabilities looks like it will be treated as a normal withdrawal. In other words, that the withdrawal tables will be used. We would like that because it will take away some of the complexity, but the taxation has not been clarified at all, and that's why we are anxiously awaiting that income tax amendment bill any day now. Who will handle those withdrawals? It will be the administrator, and the cost will be borne by the member making that withdrawal. And that links into my comment that I said I am apprehensive about the feasibility of this being implemented by 1 March 2023. I don't think we have enough time to make all those changes to our systems, but time will tell. What happens when an employee passes on and has not signed the funeral benefit form? So, Lerato, here you must help me because you work under Rajan in the risk department. What we're finding at the moment is that different underwriters deal with it differently. I can tell you what the law says. What the law says is you need to nominate the beneficiary, and in lieu of that, the benefit will be paid into your estate, right? Which is far from practical in a pension fund environment. We know that members simply don't update their information. But I do know that there are some underwriters that are allowing funds to pay the funeral benefit directly to family members. Lerato, do you have anything to add?
So you are correct. I think the some of the difficulties that our members are facing is that in some instances the deceased has not appointed an estate, and what we do in that instance becomes very difficult. So you are correct in saying that each underwriter has its own. They've kind of relaxed the rules, but obviously the law says otherwise. But some underwriters have relaxed a rule to say we'll pay directly to the person claiming. Obviously, some. So certain terms and conditions have to be made before paying it directly to the person that's claiming. But overall, the law says that it has to be paid to the nominated beneficiary. If there's no nominated beneficiary, it is then paid to the estate. However, as I explained, that there are instances where there is no estate because the kind of members that we're dealing with, for example, in the contract cleaning sector, is that most of our members don't appoint estate. And what do we do in that instance? It becomes very difficult. So I think each underwriter needs to think about this very, very important, because in some instances there is no estate to pay the money into.
That is correct, Lerato. So if I can just maybe conclude there, if there are trustees attending this presentation today, I think this places an onus on you, respectfully, to take this question to your board of trustee meetings. Is there a different way in which you can style your funeral benefits? Can you try to put aside a reserve account and call it a funeral reserve account, funeral risk reserve account? Can you make it a self-insured benefit? And to try and be creative to give better outcomes to our members. We've come to our last questions. Oh, and this is again about the member portal. Our staff have signed these indemnities and we still have system problems. Do NBC Rise have another form you want our staff to sign, as well as to motivate the use of the member portal and administrator portal? Can I make a suggestion? Esther?
Yes, I was about to suggest that perhaps we should, this specific question must come directly to me so I can deal with the specific instance. And if it's a problem across the board, then we will look at it from that perspective and see how we can best fix the situation. But yeah, if we could perhaps have this, the person asking this question, if you could send an inquiry directly to our portal, and then I will deal with it directly so that we
Thank
can
you,
resolve
Esther.
it. Thank you.
Thank you.
All right, I think then we're done with our questions for today, which concludes our presentation for today. We hope that everyone got something out of this. And please remember that you have to download your CPD certificate right after this stream has ended. It will not be available days, weeks, or even months after this webinar has concluded. And also, please, if you have some time, please could you just assist us with completing the survey? It just allows us to ensure that we get some feedback from all of our attendees in order to keep trying to improve our webinars. And thank you so much for joining us. Should you not have caught this live, thank you for watching the recording as well.